practical everyday actions that actually guide how people work within our organizations. So over the next 40 or so minutes, we'll be able to explore how our organizations can move from policy to practice by embedding data protection into our operations. We'll talk about managing personal data, putting meaningful controls in place, what measures we can put in place that will actually operationally reduce privacy risks, and also how to build a culture where privacy is understood and valued within our organizations, because it's not something that's owned by one individual, the DPO, it's owned by the organization as a whole, because a leak, a breach can come from anywhere. So yeah, let's get into it. We can maybe start with a quick introduction on, we've gone into who I am as a person, but maybe you can also gain an understanding on where I'm coming from. Let me also briefly introduce where I work and the kind of work we do. I work with a company called Rumo Services. We have our focus tailored towards supporting organizations to move beyond on-paper compliance and towards building practical operational data protection programs that suit their local situations. We focus on 4 key areas, with others falling outside of this scope, but these are the key areas we focus on. First, to provide training and awareness on everything you might need to know about data protection. This includes sessions for board level, senior level, and staff. We conduct external data protection audits, since we are accredited auditors, helping organizations measure their level of compliance. The next thing is we support with implementation, which is really the bridge between policy to practice. Okay, these are the promises you have made in your policy, in your retention policy, in your publicly available data processing policy. So now how do we move this from a promise we have made to something we actually do? So we help organizations that operationalize their privacy policies, carry out data mapping exercises, and develop governance tools like records of processing activities. And lastly, we provide DPOs. We provide DPOs our own services and advisory in something we call DPO as a service. We're able to provide guidance, oversight, and structured compliance management to strengthen your organization. We've worked with, I won't go into individual companies. Maybe we can just talk about the range of scope of industries that we've worked with. We've worked with the finance industries, with banks, with fintechs, with asset management companies. We've worked with insurance companies like CIC, ICA Lion. We've worked with circles and cooperative societies. We've worked with telco companies. We've worked with schools who handle the data of minors. We've worked with hospitals who handle their own categories of sensitive personal information. And we've also worked with regional overseers. And our partners include the Office of the Data Protection Commissioner, that is the regulator in Kenya, the Eswatini Data Protection Authority, the regulator in Eswatini. With them, we've worked on training and regional capacity building efforts for their DPOs. We've worked with OneTrust as one of our partners. They are a platform that help other organizations as well manage their privacy compliance in practice. We worked with PCB. They support our work by providing internationally recognized training and certification. And we work with IBM as one of our technical partners. So yeah, let's get into it. From policy to practice, that is the topic of today, how to make data protection within your organization on an operational manner. The session objectives are looking into the gap between the policy and how to actually practice within organizations. We look at practical approaches for how this can actually be done using the tools that are available to us. To do so, we will outline the tools themselves, the processes with which these tools can actually be used, and the governance structures that need to be in place to make sure that these tools are used as they're supposed to. Then we can just close out the session by looking into lessons from organizations that have successfully implemented these privacy practices, because there are certain outcomes that we expect at the end of this that you will be able to reflect within your own organizations after this has been put into place. The first is to gain an understanding of data protection so that you can understand where your policy falls in place within the data protection point of view. We'll be able to now define where we're coming from so that you can understand where these key items that we'll be discussing today will be applying. Because data protection as a whole is a very wide area. So maybe what we'll do first is to point out what area we'll be working on today, starting with common mistakes and pitfalls that we'll need to avoid even as we go on. So from the many organizations we've worked with, we have been able to note a few recurring issues that I might want to point out before we even go into too much into this. And one of the biggest mistakes is that while policies exist, and these policies are promises to your data subjects on how you're processing their data, these policies are not supported by regular standard operating procedures. They're not reflected in job descriptions. So no one is actually in charge of ensuring that these promises are being kept. In other words, people know what the policy says, but they don't know what to do in practice. So the policy is virtually kept on a shelf and doesn't translate to daily operations. Another common issue is a lack of a record of processing activities. A record of processing activities, a ROPA, is a very high-level document that outlines every process that your organization handles. Without a record of processing activities, you're not able to now define what it is exactly you're doing as an organization with people's personal data. Without a ROPA, you can't manage any risks going forward. You can't respond to access requests because you don't know where this data is in the first place. You are unable to demonstrate compliance. So a record of processing activities is one of the tools that you will need to actually operationalize policy and convert it into actual practice in the organization. We also often find that the DPO is not positioned strategically within your organizations. In some cases, the DPO might be reporting to a separate department that doesn't have authority over data processing decisions. This means the DPO is aware of risks within the organization, but they don't have the authority to influence decisions or enforce their own controls at all. In practice, this becomes a symbolic role within the organization. You're just able to say, yes, we have a DPO, but does the DPO actually matter within the organization? So a lot of organizations treat data protection as a one-off compliance exercise. We have a DPO, that's all. The DPO doesn't do much, that doesn't matter. They do a data mapping exercise or a policy update, and then that is shelved, nothing comes out of it. But data protection is a continuous process. It needs to be embedded into the business's ongoing decision-making and operationalization. Another common mistake is leaving everything to the DPO, even if they have authority. So from our engagements, the organizations that succeed are those that distribute responsibility across departments and build data champions to represent this sort of role within those departments, because the departments themselves are the ones who understand what sort of processing activities occur. If the DPO is the only one responsible for data protection implementation within the organization, then the whole task becomes impossible. And finally, the last thing we've noted is a lack of awareness. It's a major issue. We've seen staff who have never read the policy. It's been published, it's publicly available to all the data subjects. Staff themselves are data subjects, and they also have a role in ensuring the policy is abided by, but the staff themselves have never read the policy, and they don't understand how their own daily tasks affect privacy and security across the organization. Without awareness, the policy itself is meaningless. And policies that are not aligned with the business processes as well are also not that important and should also be updated. The policy might sound good. If it doesn't reflect how work actually happens, it creates a gap between what the policy says and what people are actually doing. So even if the policy is good, there's no way of knowing whether it's actually working. We also see a lack of incident response and breach management planning. Organizations might have security measures in place, but they don't know what to do when something goes wrong. And lastly, we see poor retention and deletion controls. Organizations keeping data just in case it might be useful someday, and without applying data minimization in practice. This creates an unnecessary risk of loss of data whenever a breach occurs. You have more data than you actually should be keeping. That means you have more data to lose. So just keep these pitfalls and mistakes in mind, even as we continue on with the session. You'll be able to see where these gaps actually might come up as we continue on, and be more aware of them and the risk of them and where they need to be closed. So what is data privacy? At an organizational level, privacy needs to look more practical than it actually is. It shows up in things like the policies that you define and how personal data is classified within your organization, how data subject rights are handled, and how the organization ensures that personal data is collected in a lawful manner. Section 10 of the Data Protection and Privacy Act is a good starting point to begin understanding this. It makes it clear that personal data should not be collected, held, or processed in a way that infringes upon the privacy of a data subject. In simpler terms, it forces the organization to think carefully about its data practices, not just whether or not it's more convenient for the operations of the business, but whether it's actually justifiable and auditable before the regulator and before the data subject. Section 11 further helps us translate this into action by setting out how personal data should be collected. The general rule is that data should be collected directly from the data subject with limited and clearly defined expectations. It's important because this affects everyday processes like how you set up your onboarding forms or admission forms, how you set up your customer interactions and acquire data from them through those interactions, as well as how you design your systems. So when privacy is applied properly, it becomes a tool to help organizations identify which data is important and why it's actually important. Once this understanding has been built, it can then be documented through your policies, through your procedures, and through any publicly facing notices that are guided by the Act itself. And this is how privacy moves from being an abstract right of the data subject into something operational. It informs how data is collected, how data subject rights are enabled, and how staff are expected to handle personal information in their day-to-day work. The next item we should look at is security. Data security is the other arm of data protection. Where privacy helps us decide what data is important and why we are collecting it, security focuses more on how the data is being collected and why it's actually being collected. At an organizational level, data security focuses on preventing unauthorized access to this data, misuse of this data, the loss or exploitation of this data as well. This includes protection from external threats in the event of cyber attacks, but also internal risks such as excessive access or poor handling practices. Security also plays a role in maintaining the integrity of data that is in our care. This means ensuring that data is accurate, that it is reliable, and that it remains available to all authorized users whenever they need it, because access is also a right of the data subject. If data is altered, lost, or made unavailable, it can affect operations just as much as a privacy breach. So in practice, data security is implemented through a combination of methods and processes. These include things like access controls to ensure that only the right people are able to see this data, activity monitoring to detect any unusual behavior that might be occurring, as well as network security measures to protect your active systems, as well as your passive systems like your backups and archives. It also includes practical safeguards such as encryption, multi-factor authentication, for example, and having an actual clear breach response process so that your organization knows what to do whenever something goes wrong. The key point is that security does not exist on its own. Again, it exists to work alongside privacy. It supports privacy. So once privacy decisions have been made about what data should be collected and how it should be used, security procedures come into place to provide the controls that make those decisions enforceable in a day-to-day basis or operation. So maybe you can take a look at this diagram that kind of illustrates how data security and data privacy both fall under data protection as a whole, because those are the two items that make up data protection. Under security, you will have encryption, network security, access control measures, activity monitoring, and your breach response processes. Under privacy, you have data discovery and classification, where you define what data you're collecting, how you handle your data subject requests, how you handle consent acquisition and withdrawal, how you handle third parties, how you handle data removal. And within privacy is where you have policies embedded, which is where you define to your data subject what data you have collected from them, why you have collected it, and what rights they have in regards to the data that is in your care, what third parties you're sharing it to. This is where you inform your data subjects of whether you carry out any automated process decision-making on their data, and where you inform them of how they can reach out to you if they have any concerns. All of this is now defined within policies. The reason we've gone over this entire initial section is so that you can see the entire structure of data protection as a whole and gain an understanding of where policies sit within the whole data protection hierarchy. So policies are defined under privacy, as you can see here. And in most organizations, there exists a bit of unexpected imbalance between the two components, and that's where things start to go wrong. So sometimes you'll find a company with very, very strong security systems. They have firewalls, they have access controls in place, they have multiple backups in case one system goes down, but they still collect far too much data than what they need. That means they're very strong in security, but they have a weakness in privacy. People end up filling long forms and no one ever stops to ask whether the information is really necessary. So even though data is being protected very well, the organization is still putting people's privacy at risk simply by collecting too much information. Other times, the opposite is happening. There are very, very detailed privacy policies and procedures in place, but they don't translate into everyday action. These policies will be sitting in a folder or in a shared drive, and staff don't know how to apply them. So the organization looks very compliant on paper, but nothing has actually changed in practice. And then there are cases where security measures exist, but there's no governance structure behind these security measures. They've just been applied on a broad-based manner. This means there's no active monitoring occurring, no accountability or report generation occurring, no records about what's actually happening with personal data. So even if something goes wrong, the organization doesn't know doesn't know who was responsible or what to do next. And this imbalance is actually the most common situation in organizations where they have security without privacy or privacy without enforcement, or both occurring without any governance. And that's why data protection implementation in practice becomes very, very difficult. And that's what we'll now look into operationalizing today and improving. The key point is that an organization only truly approaches data protection compliance when there's a balance between security and privacy. Because if you have strong security but no privacy governance, you simply don't have, you may be protecting data that you shouldn't even be collecting in the first place. That's why compliance is not achieved through documentation alone, and it's also not achieved through technology alone. It's achieved when privacy defines the rules and security actually comes in to enforce those rules that you came up with. Both of them working together as one creates a wholesome operational governance system. And that balance is what today's session is about. Now let's get into it, how to actually carry this out now that we have a bit of an understanding of where we're coming from. So my assumption is that I'm talking to DPOs or people who hold equivalent roles in the privacy space. So I will address you all as DPOs. As a DPO, your first priority is to establish a clear and accurate view of how personal data is moving within your organization. The way you do this is through the process called data mapping. Data mapping allows you to understand what data you're collecting, where it is being stored, who at all accesses it. It should indicate why this data is being processed and how it's flowing across the different systems and departments within your organization. Importantly, it should also show wherever data is leaving your organization, entering the care of your third parties, your vendors, or your processors. So data mapping does not require the purchase of any expensive software. In many cases, all you need is a well-structured spreadsheet or a simple flow diagram to show what data you have and where it's actually moving to. So the value doesn't come from the tool, but in you having the discipline to keep updating the document itself and to keep doing it in an accurate manner. So once you have a data map in place, you already have the beginning of a governance system. It becomes the basis for your risk assessments. It becomes the basis for your data protection impact assessments. It becomes the basis for your security controls and where they will apply. It becomes the basis for your ongoing monitoring activities. And because your data map should be considered a living record, you are expected to continuously update it even as your business evolves. So I will demonstrate the components of a data map in the next slide to explain how this is actually done. But I will say here, though, that a data map will help your organization understand what it has and what it's doing with that information, which is step one before you actually figure out step two, whether you're actually meeting the promises you made in your policy. You need to know what you have, then you weigh it against your policy to see what promises you made in that policy and whether you have met those promises. All of this is achieved through the tool that is called the data map. And here is the personal data lifecycle as it applies to your data map. In summary, the data map will outline the journey taken by personal data by following it from the moment it enters your organization to the moment it exits your organization's control. The first stage is collection. This is where your data map will always begin. So personal data can come in through many, many sources. You can think of it as, you can think of online forms, physical forms that your data subjects will fill, your website's cookies, your mobile applications will be another source of information. Emails are a source of information. Your CCTV systems are a source of personal information as well. Any data you receive from third parties is also a source of information. It's something you collect data from. At this point, you already need to be asking yourself some pointedly legal questions. Why are we collecting this data in the first place? If your organization never uses cookies, why do you have cookies enabled? They provide no value. So what is the lawful basis for collection at this point? Is it consensual? Is it a contractual obligation? You need this information to actually fulfill the contract you have with the data subject. Is it a legal obligation? Is it to for the sake of for the sake of vital interests, or is there any lawful ground that allows you to collect this information? This stage, as you can see, is linked directly to the principles of data protection as well. It's linked to lawfulness. It's also linked to fairness. Is it fair for you to be requesting this information from me before you provide me with this service? Is your process transparent, or have you hidden the reasons why you collect this data? So individuals must be told that you are collecting their data. They must be told what you will use it for and whether it will be shared with anyone else past that point. It's also linked further to purpose limitation. As you fill in this section of your data map, you will be able to see if you're collecting this data for a clear and lawful purpose. And you'll be able to see whether or not you're collecting the information you need to fulfill that purpose, or if you're over collecting at this stage already. The second stage is now processing, where you define how the data is being used or analyzed after you have collected it. For example, in a HR setting, this could be for payroll processing. That is now your process. You will indicate that as your individual process under HR, if your data champion is from HR. Or still from HR setting, is it for performance analysis? That is your purpose of processing. You will indicate what data you collected and where it went to be used for. In another setting, it could be used for profiling. It could be used for customer support. You need to verify that this person is, to begin with, your customer. These are their contact information, where you'll be able to now offer them support further on. That is now your purpose of processing, the processing activity that you collected the data for. Or is it for the sake of delivering a service? This is where you will indicate all of the processes as they apply under different departments. It's where purpose limitation becomes a practical activity. So as you map your processes with it at this point, you should be asking yourself whether the data is only being used for the purpose for which it was originally collected. If the use expanded, if you collected this data for the purpose of fulfilling a contract, and then you started marketing, that's a risk you've already flagged at that point. This means that the data map is already doing what you are trying to fill it out for. The third stage is storage. So personal data may be stored in the cloud. It could be stored on premise within your locally available systems if you have your own servers. It could be stored on physical files. So here the focus shifts a bit further from what we're looking at and into integrity and confidentiality. Those are also you should hear those words and also hear them being echoed from elsewhere. You mentioned integrity, that you handle data with integrity and confidentiality in your policy. Here is where it actually applies. Here you will start asking yourself questions like, how secure is this data while it is sitting in this system? It's a physical file. Where do those physical files go to? They go into a filing cabinet. Do those filing cabinets have locks on them? Those are the questions that will arise as you fill in this section of your data map, the storage section. So are physical files kept in locked cabinets? For digital systems, the question will be, do we have role-based access? Do we have strong passwords in place? In the event that a password leak occurs, do we have two-factor authentication activated on our systems to be able to mitigate the risk that will rise from passwords being lost? What other security controls are in place for the data that is in the cloud compared to the data that we keep on premise? And how should we raise that security? So as you continue on and indicate your different storage locations, you will also indicate what security measures have been applied. And at that point, you will be able to notice any gaps that might occur with your storage practices. Storage is also linked to the principle of accuracy. So organizations are required to ensure that any personal data they hold is up to date, is accurate, and is complete. So this means you will need to have a process in place for regular review and correction of data that you hold, and allow your data subjects also to have access to this data to correct any inaccuracy or to enforce their erasure requests at this stage. So as you can see, another purpose of processing, at this point, you also apply accuracy as a principle. And this is how you are able to operationalize the promise of accuracy that you had made within your policy at some point. The first stage that we move on to is sharing. And this involves looking at all third parties with whom you share an individual's personal data. A third party is anyone other than you, other than the data subject and yourself as the data controller. Anyone else that receives access to this data outside of these two is a third party that you share the data to. So employees are part of the data controller, so there's no worry on that part. But service providers are not. They are third parties. So these third parties often act as data processors. And at some point in your policy, you will indicate that you share your data to some third-party processors. This part of the data map is where you list all of your third-party processors. This is how you operationalize the process. You need to actually know who your processors are. And examples aren't just people you send data to in emails, like if you're a hospital sending it to an insurance company. It's also, counted among third parties is also your cloud service providers, any payroll vendors you might have, because your employees also count as data subjects with whom you have from whom you have received data from. Any IT support firms that remotely log into your systems will also have access to personal data, so they also count as a third party. They also need to be indicated at this point. Any person, even just a person, a singular person, it doesn't have to be a company, any singular person or entity that you engage with to carry out a task on your behalf becomes a third party you have shared data to. Even if you did so because it's easy or cheaper, or you required specific expertise, they are now a third party. You will need to indicate that at some point we might need this third party individual to access this personal data, and therefore you will need them to be reflected within your data map as well. So at this stage, you should be asking whether you have proper data processing or data sharing agreements in place. And after listing all third parties, you will now be able to list if you have a data sharing agreement in place with that third party. That is how you operationalize that part as well. At that point, you will also be able to keep track of whether the data sharing agreements cover the scope of everything within the documentation you shared or collected for this purpose, or if some of the data falls outside of the scope, and you'll be able to now update the data sharing agreement. Because the scope of the agreement you had initially might have been exceeded at some point by additional processes that you might not have thought of at the time of initial contract signing. So as you fill in this data map, as you take a second or third look at these third parties, you will be able to note any gaps that might exist due to ongoing or changing processes. That is what we mean by calling this a living document. It allows you to take a second, third, fourth, fifth look at the agreements you have in place and see whether the agreements are actually sufficient or if amendments need to be made to your agreements. And the final stage of the data mapping process is deletion. When you collect the data at the first step, you need to also indicate when this data will reach its end of life, because you're not allowed to keep data into perpetuity unless there are mitigating conditions. You need to indicate when this data will come to its end of life, when it will require deletion, archiving, anonymization, pseudonymization, some form of removal of the personal identifiable information. So this stage relates directly to the principles of storage limitation, which is something that you will have promised your data subjects within your privacy policy. Personal data should not be kept for longer than is necessary for the purpose for which it was collected. So creating a data map will help you see where data might be stored for longer than is actually necessary, and where and when retention promises should actually come into place. So the key takeaway here is that as you map each stage of the life cycle, as you map each process, as you map each source of data, you're not really just documenting a data flow. You are identifying compliance gaps even as you go, as well as any high-level risks that you might not have been aware of that will need immediate addressing. This is the personal data lifecycle, and the tool here, the name of the tool is called a data map, which is what you will be using to achieve the mapping of this personal data lifecycle. Once you have your initial data map, you then need to make sure that it is maintained as a living document. Think of your data inventory not as a one-time task, but as a resource that your company will now own that will always be a reflection of what is actually happening to personal data within the organization. As with any living tool, it will require regular reviews and updates. These will be key to actually ensuring that the document stays alive, stays useful, stays accurate. So the next thing to actually do at this point is to schedule periodic reviews to check, to make sure that the inventory is up to date with any changed processes, any new processes, and to keep it alive. One way to make this happen is to keep the document electronic. Having your data map in an electronic format will make it easier to update the document, to manage versions of the document, and to share it as well across departments. Because as we said at the beginning, data protection is not owned by the DPO. The DPO does not know what IT might be doing among all of their processes. Only IT understands all of their processes within the department. So keeping the document in an electronic format will allow it to be easily shareable to all departments. They will be able to note, yes, these are our processes, but there are a few more that we'll want to add to this list because these aren't everything that we actually do within our department. So paper records don't actually work for something like this. It's a document that changes so often. So you need to embed updates to the document into your business processes, into your job descriptions, into your standard operating procedures. Staff need to know that any new product, any new service or initiative that uses personal data should be added onto the data inventory. This needs to be done through a representative in each department called a data champion. It will be part of their job description to actually keep this data map updated for their department, with the DPO having overall view of the changes that are being made, as well as control of the different versions of the document. So this is how you make it part of your business or organization structure, by starting from training to make them aware of its importance, and making it part of the job description and making it part of the culture to keep this document alive. And finally, you need to manage the obsolete activities. Any processes that are no longer active should be either clearly marked as inactive in case they're ever brought back, or if you want to keep them on record, or they need to be removed from the live data inventory. If you remove the process, though, you need to make sure that you archive a version somewhere for accountability and auditability purposes. Because a client might come back in the future and ask for a copy of their data. You will ask for what year are you requesting a copy of your data. Then you'll be able to now go back into the data map from that year and track every location where their personal data might have been shared across from start to finish. If the data was deleted, you'll be able to indicate that your data appears to have reached its end of life and was deleted at this date per our inventory. That is one of the use cases of a data map. So anything that's no longer active should be clearly marked as inactive and removed. And if you remove it, keep a version somewhere because it will still prove useful at some point in time. Once you've mapped the data, the next step is your self-assessment. You do this by creating a cross-functional team of data champions across different departments. And these representatives from these departments will act as you, the DPU's eyes and ears on the ground. They'll help you maintain the data map. They'll help you support in identifying any risks that might arise as soon as they know how to identify them. So data champions play a key role in their departments because they are not only in charge of creating the data maps for their departments, but also for indicating when a DPIA might be required for any new processes or any high-risk processes. And they will also be the owners of the outcomes of these DPIAs. A DPIA is a data protection impact assessment. It's an assessment you put a process through to find the risks that might arise and assign ownership of these risks. But you can't actually carry out a DPIA without knowing what these processes are. So the process of carrying out a DPIA using the tools that come with a DPIA will only come into play after you know what data you hold and what processes this data is subjected to. So the main tool here is the data map. After the data map has been populated, is when you can now carry out a data protection impact assessment, either as the DPO, or you can assign the task to be carried out within these departments by the data champions that you assign these roles. So again, this is, as you can, at this point, I think you can be able to see how we've mapped the process from carrying out a data map. As you carry out the data mapping process, you'll be able to now note the risks and carry out a DPA on the risks, carry out a DPA on the processes, find the risks, and close these risks. So when we look at organizations that have done data protection well, not just on paper, but have actually turned it into a practice or a daily operation, there are some consistent lessons that can come up again and again. The first is that successful organizations start with visibility. They take the time to understand what personal data they actually hold, where this data came from, where it is moving to, and who has access to it. Tools like a data map, a processing tools like a data map and processing inventories will help them to actually see the full picture of the organization, because it's really difficult to get to protect data when you don't fully understand what you actually hold. The next lesson is that you shouldn't treat privacy as a policy document that will just sit on a shelf or within your files. Instead, you need to embed privacy into your operations to translate these legal requirements into clear internal procedures through a data map, into things that the staff can actually see and follow in their day-to-day work. This is how you make privacy into part of your workflows, into part of the responsibilities of your staff, and into the decision-making processes of your organization, not just a compliance document that you have filed. They also take a risk-based approach early. Organizations that do well use tools like DPIAs proactively, especially when they're introducing a new system. You'll want to know what risks come with this new system. You'll want to map this new process onto your existing data map to find out what data you will need to actually fulfill it, and to find out where you will actually terminate this new process. So when you adopt new technologies or work with new third-party vendors, these processes will help you identify risks before any problems actually occur, rather than trying to fix the issue after the fact. Another key lesson is accountability. A strong privacy program built in this manner will be supported by the governance structure in place, by using active DPO involvement, using the privacy committees that will be built through your data champions, using regular audits, data protection audits, using a clear reporting lines from the DPO to the board on the findings that are made as data maps are continuously updated. So in these organizations, privacy is owned, monitored, and taken seriously by everyone at the management level, and using the existing reporting structure. Organizations that succeed also invest heavily in staff awareness, because ultimately privacy is not the responsibility of the DPO, it's everyone's responsibility. Every employee across all departments needs to understand that data protection is part of their everyday work, whether they're handling customer data, student information, whether they're handling HR files or financial records. And lastly, successful organizations also pay close attention to their third parties. This is important because many privacy risks come from outside the organization. So they put strong controls in place with data protection agreements, with vendor due diligence, and with ongoing oversight to ensure that external partners meet the same requirements. Let's just bring this to a quick close because I'm aware that time has been moving on. At this slide, you can see an effective data protection outline. You can also see that it's not a one-time thing. It all ties into a governance and monitoring framework, which is what we've outlined in the previous explanation, beginning with training and awareness, because the staff, the board, the DPO himself, the data champions need to be aware of their roles. Privacy only works when everyone across the organization understands their responsibility. And a policy is a meaningless document if staff don't know how it applies to their daily work. Then the next step is visibility, which is what we have outlined. This is where you turn policy into practice. You have outlined the policy. This is the promise you have made to your data subjects. How do you actually operationalize it? You operationalize the process into a practical application through a data map. And after the data map, you will now be able to carry out the privacy impact assessments. So you can't protect what you can't see. Then at that point is when you carry out the privacy gap analysis. You're able to take a look at your current process. Each process, you'll be able to find the gaps that are involved and be able to now assign ownership to these gaps to actually ensure that they are closed. Are we retaining data too long? Are our vendors accessing data without any controls in place? Are our security measures not up to par? All of these will be covered in the gap analysis after you know what data you hold. Then we move on to implementation, turning all of these findings into controls, into updating our procedures, into creating access restrictions, updating our retention schedules for each process, into enforcing stronger vendor governance, into ensuring that we're ready for any breaches that might occur or any incidences that might occur by assigning ownership. This is the point where privacy becomes operationalized after you know everything that you needed to know during the data mapping process, because the data map is the key tool that will advise how you carry out your implementation. All of this falls under the governance and monitoring framework because, again, it's a living document. It's something that you're continuously updating through new metrics, through audits, through accountability reporting to the board, and through ongoing involvement of the DPO and leadership in this process. So the key message to take away is this: privacy is a cycle. It's not a checkbox. It's an ongoing thing that should be considered and used as the basis within which you run your operations. All of your operations should be reflected within the data map, and that will advise you on what the next steps will be. I hope this roadmap will help you take your policy implementation in a more practical manner and place this control further into your hands, and that you'll be able to now understand how the importance of this process. And thank you again for your participation, and I hope this roadmap is as helpful to you as it is to us as well. So I've tried to keep an eye on time. So right now we are at the Q&A session. So maybe you can just let me close the first poll, and you guys can raise any questions you might have at this point.
Yeah, thank you so much, Bernard, for that very insightful presentation. We, of course, appreciate the time and expertise you've shared with us. The presentation has really, really been practical. And I believe for the rest of the participants, we have been able to learn a thing or two. Now, to go into the questions, I'll just open the Q&A. Or are we running the polls, Bernard, just to confirm?
Oh, sorry. I wanted to run it so that it could be running in the background, even as we answer the questions.
Do the questions. Okay. Okay. So members, as we do the Q&A session, please take note of the polls that are running and give responses to them. Okay, so I'm going to be reading about 2 questions. You respond to them. That's going to be the order for the Q&A session. So the first question is, if you're able to look at the Q&A panel as well, Sadiq says, could you avail us with a standard consent form for collecting different types of data, such as photos, pictures, names, etc., during program implementation or research and release? Now, the second question I'm going to take now is, for how long can we store or keep personal data within our archives? Over to you, Bernard.
Yes, thank you, Anita, and thank you, Sadiq, for the questions. These are they're very important questions, and you can see where you're coming from. The question on availing with a standard consent form for the collection of different types of data, such as photos, pictures, names, etc., during program implementation. Now, this is very limited because there is no standard consent form for different types of data. Instead, your consent form should be tied to your processes. Maybe it was not as clear. The process could be something as, if you were at a school, for example, you're at a school teaching children between the ages of 6 and 10 or 12. One of your processes would be admissions, how you admit new students into your school. So the data collection that you'll be taking is the student's name, the parent, the guardian's information, the students and the guardian's information, basically. So at that point, that entire admissions activity is a process that will be reflected on your data map. And the purpose of processing is for admission of the school and fulfillment of and provision of the services. So there is no standard consent form that will actually be tied to each and every use case. Instead, you will be tailoring your consent forms for the purposes for which you're collecting the data. So first, you're looking into the purpose of processing. So we are collecting this data for the sake of admissions. So do you consent to that? And if you at this point, you're also able to outline to them, if you're unable to provide us with this information, we are also unable to continue the admission process. So they are, at this point, you can see there is no standard. It's tied to your processing activities as it is. So the point at which you will require consent, where you might need to make it a standard activity, is if you take marketing as a whole. We are hosting an event, we will be taking photos, and as you enter, we require you to sign a consent form, allowing us to use the photos and videos that we take for marketing and commercial purposes. That is where you use a standard template for every marketing activity that you carry out as they enter. But again, as you can see, this is another process. It's a marketing activity. It comes with its own consent form. You're indicating that you're collecting information for marketing, specifically photos and videos, and you will also indicate to them, their rights. You're able to now contact us to withdraw your consent at any point, and we will do so. So there is no standard for each and every one. They're all tied to individual processing activities. So you will fill it into your data map, what your processing activities are, and what your purpose and what your legal basis of processing is. And at that point, that will inform you of whether or not you needed consent at that phase. So it's not something you get a standard for. It's based on what you find on your data map. The next question is how long you can store personal data within your archives. Again, no standard answer. Financial information, you paid, and let's say payroll information, you paid your employees their salaries. The regulator needs you to keep that information for a certain number of years. But for a marketing activity, this person already withdrew their consent. So for one, you are required by a different regulator to keep that data for a certain number of years. But this other one, they withdrew their consent from receiving marketing. So that one, you need to immediately delete their data because they also request the deletion of their data. But the other one, you have the permission. You don't need the consent of the data subject to keep their data. You're able to keep it for a number of years. So all of this is further, again, advised by your data map. You will take a look at each individual process. Here we're processing for marketing. It required consent. As soon as they withdraw consent and ask for deletion, we delete it. You don't keep it in archive. That is the end of life for that data. It immediately comes into play when consent is withdrawn and when they ask for deletion. But for payroll, you need to indicate you pay this individual because another different regulator might want this information later on for tax purposes, for audit purpose, for a financial audit. So in that case, even if the data subject requests you to delete it, you will say we are archiving this data for a certain number of years as required by a different regulator. So really, this again ties back to the data map. You need to track down each individual process and give it its own end of life. That is what the data map is, what will advise all of this. You will look at all regulatory requirements and see what requirements are placed upon you for the retention of this data. I hope that one has been answered at least. More insights on how it is.
Yes, Bernard?
Yes.
Yeah, thank you so much. There's a question I wanted you to take after the one you just answered, which is a bit related. I don't know if you're able to see a question from David Fugonza. He says, thanks for the presentation. We are an organization doing community work as well as providing medical services. Medical services have a lot of data, including name, place, age, district, diagnosis, etc. We have records for clients that we have kept for over 10 years now, and we feel we need to dispose it off. What are the procedures of disposing such data?
It's a very good question. It ties into medical services. So I can see diagnosis there. So that is also sensitive personal information. There will be financial records involved there as well. There is, of course, the regular personal information that you expect out of this: name, place, age, district of origin. So at this point, what you will need to do is to, again, first carry out a create a data map to find out what data you actually hold for these individuals. Map the processes, map what departments they're being held in, map the storage locations. Then you need to take a look at your policy. When you collected this data, you had informed your data subjects on why you were collecting this data and for how long you would be keeping it. Then you ask these individuals to actually agree to your policy. So the problem here is if you carry out a wide-scale deletion of all data that is beyond 10 years of age, you might be infringing on an individual's right to access their data at a certain point if you have done it against what policy you had provided them. So they might come back and ask for, their medical information because they need to get advice from a specialist. And at that point, you can't tell them, we deleted your data because we were trying to update our systems and clear the space. So the thing to do here to make sure that you're in the right is to create a data map and to take a look at what promises you had made to these data subjects before you actually look into deletion. So you will be able to now track down, based on your policy, what the end of life for this data was supposed to be. And that will advise you on what data you need to delete and what data you need to keep, as well as where this data is, because you need to know where the data is to actually delete it. Now, after you have found what data you are capable of now deleting, the next step is to ensure safe deletion. It's by hiring it out to a different third party that is in charge of disposal. And after they have disposed of the data, they will give you back a certificate of destruction for physical data or digital materials. So that is the next step. It's actually indicating that this data was deleted. You got a certificate of destruction, or you're able to log the deletion of a certain person's data at a certain time, basically. So that if they ask, you can say, we no longer have that information. As part of the policy you had agreed to, we were able to delete your data to actually clear our systems. But we did so in a way that respected your own rights. So start with the data map. That is the important bit. It's how you operationalize the deletion process. The data map will measuring your data map against your existing policy will tell you what you actually have the right to delete and what you actually shouldn't be deleting because you owe it to your data subjects.
Yeah.
Anita?
Yeah, thank you very much, Bernard. I am going to take two more so that you first respond to those. And members, maybe just to encourage us to type our questions in the Q&A section, because normally when they go in the chat, sometimes they are missed out because we have a lot of comments in the chat. So Julius Odongo is requesting for more insights on how to conduct a DPIA, especially when they discover high risk at mapping. And then Jonathan Chinara says, much insightful, especially on how the PDP policy should look like. I don't know if that's a data protection policy. What would be the ideal key sections of the policy besides highlighting practical processes? I feel like this is a very broad question that probably requires an entire presentation, but Bernard, I don't know how you would want to approach that.
Let's see how we can wrangle with this one. That one is a very broad one. It moves into implementation after you've already found what you have. Yeah, it's a whole topic, but we'll see if we can maybe give a general idea. So starting with Julius Sodongo's question, more insights on how we can conduct a DPIA when we discover high risks at mapping. So you discovered risks, very good. That means that the data map was carried out to a satisfactory degree. You're able to find all of your processes and note the ones that require a further check. How to conduct a DPIA when you discover high risk at mapping? There are different DPIA templates that are provided by each regulator, which they prescribe organizations to use, organizations within their own countries. If you look at GDPR has its own DPIA templates. If you look at Kenya's ODPC, they have their own DPIA templates published on the website. If you look towards Eswatini, they have their own DPIA templates. So the first step is to look towards your regulator, ask them, or look onto their website for any publicly available resources. Ask your regulator, is this what you advise us to use? So that you make sure you're using the correct template, actually. They are usually publicly available. And the template itself will describe to you how the DPA should be filled, who should own what process. And at the end, the DPO will be able to sign off on it, saying that all of these are the risks we found in regards to this processing activity. And these are the owners we have assigned these risks to make sure that the risks are actually continuously monitored. These are the mitigating measures we put into place. And as the DPO, I either agree with us going forward with this processing activity because we have put up the mitigating measures for these risks, or I reject the continuation of this processing activity. And at that point, someone in the board is able to override or accept the DPO's decision to continue or stop the processing activity. If there are risks available in the DPIA that you are unable to mitigate, at this point, you're able to also submit the DPIA itself, the field document, to the regulator and ask for advice on how you can actually continue your processing activities, because it could be a process that is core to your business operations that you cannot stop, and that is probably widely available across, you might be in the banking sector. So if it's a risk that's available to you, it's also a risk for everyone else. So you're able to now reach out to your regulator and say, hey, we have this process, we identified it as high risk, these are the mitigating measures, but we are not really sure on how some of these risks can be closed. So could you now provide us with advice? So yeah, that is how you conduct a DPIA. Just first reach out to your regulator. They'll have advice on how to do it, how to fill it. You'll be able to now reach out to them again afterwards with how to close those risks that you find. I hope that one covers that one. Well, that description covers that well enough. On how the policy should appear, what would be the ideal key section of the policy besides highlighting practical processes? The key sections of the policy should, yeah, this is a very wide topic, but maybe you can just give a general look at it and then you can do some further research later. At the very end, you usually notice the organizations that publish policies that are considered good have placed a DPO contact email or a channel where any data subject requests or complaints can be funneled to. So your policy should indicate how data subjects can be able to reach out to your organizations in the event of them wanting to exercise their rights. That is one of the key areas, because if they've noted a breach of their data and they don't know how to reach you, how can they report it and get it acted upon within a good time frame? There are statutory timelines associated with all of these requests from data subjects, and it's some of the breaches that might occur need to be acted upon really quickly, like a leak in financial information or health information. So you need to make available a method for them to reach out to you. Something that you might also want to add is a list of their rights, because you have promised, they are giving you their data, so you need to indicate what rights they still have in regards to their data. They have a right to correction, they have a right to be forgotten, they need to consent to the whole thing to begin with. You'll indicate that some of the data is being shared to third parties, some of the data might be leaving the country. These are the things you just want to indicate in the document itself. The document on the privacy policy as well, you might also want to indicate. It's a very wide topic. Let me just leave you with that as the key items, because this one will need to. This goes into implementation, because the policy itself needs to also be customized towards your organization's processes. So after you know what processing activities you carry out, you customize your policy to actually reflect those processes. As an example, one is a school and one is a bank. One is handling minors' data, with the rights of those minors being in the hands of the parents and guardians. So you would need to customize your policy to actually be speaking to the parents and guardians on behalf of the children, or the children themselves once they reach a certain age. But for banks, they're handling financial data. You will also need to indicate to them, you have a right to be forgotten, but we need to keep your financial records past a certain point. So the retention policy might be a bit different for the bank compared to the school. So again, it needs to be customized towards your processes. So again, start with a data map, outline your key processes, and then this will also now further advise how you will customize your policies at the end. I think that's the most general explanation I can give on how the policy will be crafted.
Yeah, thank you very much. I hope participants, for those asking questions, you have been answered. Now, Bernard, I understand we have run out of time. I don't know how much time you have, but if you don't mind, I was thinking we could take about 3 more questions. I don't know if that's okay with you.
I'm fine with that.
Okay, so the first question is, how can an organization ensure third-party vendors maintain equivalent data protection standards, especially when data crosses borders? That is the first question from Isaac Sechito. Then there's another question from Martha. Martha says, with the various kinds of data and forms of collections ranging from data collection tools to hard copy procurement forms. How can we create a centralized inventory? Like, do we need to change everything to one method of collection in order to create that inventory? And maybe the third question, let me just read it as well. Yahaya Kagwa says, given that we hold sensitive client, personal, and financial records, what key controls should we prioritize to ensure client data is protected throughout its life cycle from correction and storage to access and disposal? Over to you.
Those are very good questions. Yes, let's go over them quickly. Again, I've activated the fifth poll over there, so as you listen, you can also interact with that. So the first question, how can an organization ensure third-party vendors maintain equivalent data protection standards, especially when data crosses borders? How to ensure that they maintain equivalent standards to your organization? That should actually be discussed during the vendor onboarding process. You have identified a vendor that will provide a service that is required for your own operations. Now it is to make sure that during the initial negotiations, your own requirements are being met even by these vendors. So let's take a look at past vendors. Go back into your data map. You will be able to track those past vendors, those vendors that you already have agreements with, and take a further look at their own policies. So the first thing to look at is whether or not they have a policy of their own that defines where the data is being moved to, or have it as a topic during the vendor onboarding process. And you will ask them, where is your data? What countries does your data reside in? This is a question that will come up with new vendors or with past vendors when you're doing your data mapping, and look at their policies to see what promises they're making. The next thing is doing your own due diligence. So you yourselves and your organizations are registered with the regulator as a data controller. These vendors are your processors. Are they registered as a processor with the controller? That is also one of the initial key items that you'll just check up on as part of the vendor due diligence. Then the next thing is with your third-party and vendor agreements, your data sharing agreements with these vendors. They need to be thorough. You need to define within that vendor sharing agreement what you expect for them to be doing with that data, what you expect them not to be doing with that data. So if they have indicated that their data moves from Uganda to the US, to Germany, and to China, you can place a restriction on that. You can say to keep in line with our own data protection policy that our clients and data services have agreed to. We do not want you to share our data to China because that goes against our own policy. So at that point, your vendor sharing agreement will have those requirements outlined, and these requirements will be how you expect the data you're placing in their care to be handled. You, the data controller, are the one who has the authority to make these decisions. They only have the authority to agree or reject these decisions before the contract is actually implemented. You will place expectations on them, indicating you are only sharing these categories of data: the name, the email, and the phone number if it's a marketing company. And at that point, you will inform them that you expect them to not collect anything further than that, even as you grant them access to your systems. So it's on you to ensure that your data sharing agreements with these organizations are as thorough as possible, and only for the purpose of achieving the specific processing activity. So again, back to your data map, you will see that one of our processes is being outsourced to a vendor. Yeah, this process will have an indication of what categories of data is going to this vendor. At that point, you will be able to indicate that you have been oversharing information to these vendors or undersharing. So you'll be able to make adjustments to your vendor sharing agreements even as you go along, as you notice these gaps. So this is how you are able to now operationalize the process of creating a vendor sharing agreement using the data map, and are able to now update the requirements that you place against them, as well as doing your due diligence. Again, it all ties back into a governance framework. Even after you have come up to this agreement, it's not just your processes that are changing, the vendor's processes also changed. So they might have gotten a new server in a new country, and they need to make you aware of this change. So that will also be outlined in your agreements. If you change the way you process our data, please make us aware so that we can write up a new agreement and come to a decision on whether we'll continue working with you or not. So it's they also need to be taking these due diligence steps, but it's up to you to make sure you keep on top of it. So as part of the review cycles of whether or not you should keep these vendors whether you, and as you review your data maps, you'll also come up with a period. You'll say like after 1 year or after 2 years, we will review our vendor sharing agreements. We'll take a look at their policies to see if they've changed. We will contact them again to reestablish a new contract at that point. So it's for you to keep on top of this as you go along. On Martha's question, what with the various kinds of data and forms of collection, ranging from data collection tools to hard copy procurement forms, how can we create a centralized inventory? Do we need to change everything to one method of collection in order to create that inventory? No, the data map is separate from your data collection methods. The data map is only a record of what collection methods you have in place. So it's not, you don't really need to change unless you have seen it as an improvement in your operations. The initial data map that you will come up with is really a record of what your current processes are. And only if you see an opportunity to improve your processes to meet the regulator's requirements or improve your own operations will you need to make the change. So you can keep the collection in hard copy and in digital format, but then the question will be, at that point, are we able to get rid of one for efficiency? If
the key is that the data inventory is simply a record of the methods you currently.
Yes. It's just a record of what methods you have. If you want to make changes at that point, it will be an improvement to your methods because you've noticed a gap that you want to close, or you are now able to notice an improvement that you can make. But it's really just a record of your current existing methods. That is what the initial inventory will be. You don't need to make any changes at that point. Then the next question is, given that we hold sensitive client personal and financial records, what key controls should we prioritize to ensure that client data is protected throughout its life cycle, from collection and storage to access and disposal? This will be advised as you carry out the process. As you fill your data map, starting from the initial process allocation, you'll be able to now carry out the analysis on where the data is being stored and whether the process as it is being carried out from collection to storage is secure. So each process will be under a microscope as you fill it in, from initial collection to storage to its disposal and to its sharing. So as you go along the process, that is the point at which you will note the security measures you have in place for each step of the process. If it's collection for HR, for the HR department, you will note that you collect names, emails, and bank records. They go into our cloud storage. You will indicate at that point that this process is secured under passwords and access controls. Only the HR department has access to those. If you have outsourced it to a third party, you will say that this third party has multi-factor authentication on their own system. If it's on the cloud, for example, they have enforced MFAs, they have passwords, and again, we still have access controls in place. So all of these will be advised as you indicate them. So each process will have its own indication of the security measures that are in place. And if it's with sensitive personal information, that is when you know to enforce higher and higher security ratings. For example, what's it called? Anonymization or access controls to only certain amounts of information. So if someone in the finance department wants access to this client's information, you will place a limit on filtering out the sensitive personal information from the regular information that is required. So it's indicated within each process on your data map. That is how you'll be able to now allocate the security levels for different categories of data. I think that's the 3 questions already covered.
Yeah, thank you so much, Bernard, for that. At this point, I am going to request that we are going to have to close the Q&A section. I don't know if you have had the time to peruse through that section, but we are going to have to close it, and I'm going to hand over to you, Bernard, to give us your parting shots. And within that, I don't know, maybe you could answer a question or 2 that you feel should have been talked about. Over to you for parting shots.
Thank you so much. I'm very grateful to have had the opportunity to meet you all and carry out this session. It has been an honor to be able to share our company's expertise with you all. We have been in communication with the PDPO for a while, and being a company that's focused on the privacy segment, privacy industry, we appreciate every opportunity we get to share our expertise with the wider community, to raise everyone's awareness level of this very critical field. And because, again, personal data is the lifeblood of companies. It's what we rely on to do business. So from my perspective, from where I sit as an information technology expert, personal data is a very important category of information that needs higher and higher security rating. And being able to share this information with you today, being able to communicate with you, is an opportunity that I greatly appreciate. Feel free to reach out to us at Roma Services. You can email us at consult@roma.co.ke if you have any further inquiries and would like to seek further engagement. If you need any further clarification on how to carry out a data map, or need an actual data map to be done within a certain time frame, these are all services that we offer. And I'd like to thank you all for taking the time to attend this session. And as in regards to questions, I believe I won't take any more, since we have answered quite a number. Let me just hand it off back to Anita. Thank you so much once again.
Okay, thank you so much, Bernard. Members, for those that were asking about the presentation, this will be shared on the emails used to register for this webinar. And again, the recording is already available on our YouTube channel. A link has already been shared in the chat. Feel free to click on it and you'll be able to access it. Thank you all once again for joining us today. Your participations, the questions, the engagement made this session truly valuable. It has even been very evident looking at the number of questions that were asked and were unable to respond to all of them. And of course, a very special thank you to you, Bernard, for sharing your insights and expertise, and to everyone behind the scenes who helped make today's webinar possible. Please do send our regards to your entire team at Roma Services Kenya, and we really appreciate their support and collaboration. Members, earlier I shared a link in the chat. Kindly click on it and give us feedback on today's webinar. I have seen most of your feedback that you've shared. Feel free to share that as well in the link that I shared. That the feedback normally that you give us helps us to make future webinars better for you. And as we wrap up, I would like to encourage all of us to take what we've learned today and apply it in our work. Stay connected, stay curious, and continue protecting and respecting personal data in all that you do. We look forward to seeing you all at our future sessions, and have a wonderful day ahead. Bye.